Hey guys, good morning. Mr. Kavanaugh here. And I wanted to go over some notes that we really weren't able to get to on the judiciary, on the judicial branch. And I'm going to post these to your classroom page for you to look over along with some other review videos. Look closely at your study guide. But I just want to go through these. If you've already heard some of this, which you may have in the other classes, just fast forward. But I note this morning in R1, we were pressed for time as usual, and we really didn't get through some of the substantive information. So here we go, back to the judicial branch. Remember, Article 3 sets up the courts. You know that. Article 3. Article 3 only sets up one court, the Supreme Court, but it has language within the article that allows Congress to set up other courts as needed. So kind of a trick question. How many courts does Article 3 set up? It's one, the Supreme Court. But language in there allowing Congress to set up other courts as needed, which they will. In this country, we have a dual court system. We have state courts, local courts, and federal courts. So we have a dual court system in this country. For this exercise, we're focused on the federal court system, on the constitutional courts under Article 3. We're focused on constitutional issues, so we're focused on courts at the federal level. So you'll see that in the notes. Looking at the 3 levels of the federal court system, 3 levels, know them, 3 levels of the federal court system. So the first level are the district courts. They are the principal trial courts, and they have what's called original jurisdiction. Original jurisdiction. They are the principal trial courts. 94 of these district courts sprinkled across the nation. The closest one to us is right downtown Indy. So they are the principal trial courts. If you are arrested for a federal crime, then your first appearance will be at one of these courts. Downtown Indy. So, for example, what's a good example? Timmy's arrested for bank robbery, federal crime. So his first stop is going to be one of the district courts downtown. They are the principal trial courts. They hear the trials, and they're trying Timmy for bank robbery. They have what's called original jurisdiction. Original jurisdiction. Remember that. Well, let's say Timmy is found guilty, but his attorney believes that there's a constitutional issue at stake. Let's say when the FBI searched his car where they found the money, they did not have, or there was something wrong with the search of Timmy's car, which the evidence found in the car was used to convict him. So his attorney is going to make an argument that the search was illegal, hence the evidence should be suppressed, hence allowing Timmy to go free. So they're going to appeal to the courts of appeals. So that's the next level. So you have the district courts, courts of appeals. 13 courts of appeals scattered across the country. The closest one for us, for our district, to the 7th Circuit Court of Appeals out of Chicago. They have what's called appellate jurisdiction, as you'll see in the notes. Appellate jurisdiction. They hear cases on appeal. So cases have already happened. And they're not retrying the case. They're looking at a legal issue from the earlier case. So the legal issue in this case, in Timmy's case, is that the search was illegal, conducted illegally. So the attorney is asking for the judges at the federal level to look at the legal issue, the search and seizure issue, and determine if the search was legit or not. So let's say they do, but they determine that the search was legit and the lower court ruling was correct. So wow. So Timmy, wow, not looking good for Timmy. He's one foot in federal prison. Fort Leavenworth, Kansas, where he's going to be spending the remainder of his days breaking big rocks into little rocks. One alternative final alternative really is to petition the Supreme Court. So that is the 3rd level. So district level, courts of appeals, Supreme Court. 3 levels of the federal court system. Remember that. So Timmy's attorney petitions the Supreme Court. They don't have to accept the petition. They can deny it. They just don't want to hear the case. So what happens then? Say the Supreme Court doesn't want to hear Timmy's case. What happens to Timmy? Well, the last ruling stands. So the Court of Appeals affirmed the lower court ruling, so Timmy's off to prison. Good luck with that. Have fun. We'll send you a cake with a file in it. So those are the 3 levels of the federal court system. The district level, principal trial courts, courts of appeals, and Supreme Court. Remember that. Remember that. It's in the notes. Remember that. The primary duty of the federal courts, especially the Supreme Court, primary duty, have this in your notes. You'll see this on a quest down the road. The primary duty really is to mediate arguments between the states and interpret the Constitution. Say what the Constitution means. Say what the Constitution means. So the primary duty of the courts, federal level, mediate arguments between the states and say what the Constitution means, interpret the Constitution through the process of what's called judicial review, which we've talked about on numerous occasions. Judicial review, under the great Chief Justice John Marshall, who put the court on the map. Remember, before John Marshall, the Supreme Court was a dead-end job. It was nowheresville. It was like living in Avon. Just kidding. Remember the first Chief Justice, John Jay, he left to go be governor of New York because the Supreme Court, or the federal courts, the Supreme Court really had no power. John Marshall put the court on the map, especially through the ruling in Marbury versus Madison, which breathed life into the concept of judicial review, which had been there, but he just gave it the oomph that it needed through Marbury. Judicial review, the ability of the courts, the Supreme Court, to look at actions of the other branches of government and the states, don't overlook that, and the states, and determine if their actions are constitutional or not. But remember, the courts have to wait for something to be brought to them. Where Congress is proactive, if you're a member of Congress, you can go out there and address all kinds of issues. The courts, the Supreme Court, they have to wait for things to be brought to them. They are reactive. They have to wait for challenges to be brought to them. So judicial review, remember that. To be a federal judge or Supreme Court justice, we've talked about this before, you need to be nominated by the president. I don't like the word appointed. Appointed, kind of, if you're appointed, that kind of means you got the job, which is not the case here. You're nominated. The president will put your name forward, and then you will be checked out by what's called the Judiciary Committee in the Senate. They will vote on you, and then the full Senate will vote on you. So you need to be nominated by the president, and you need to be confirmed by the Senate. Advise and consent, which we've talked about, which is an example of checks and balances. Remember that for the exam, checks and balances, advise and consent. So, each president is going to choose somebody that follows their unique, they say, it's not supposed to be political. It is political. Politics always creeps into the legal system. It's politics, it's life. The president is going to choose somebody like the president right now, Joe Biden. He will, if there's an opening for a federal judge or a Supreme Court justice, he's going to nominate somebody more left of center, more liberal, progressive, if you will. Donald J. Trump, who was more conservative Republican, he is going to nominate somebody more conservative in their judicial philosophy. So that's how they are chosen. It is really based on their judicial philosophy in relationship to their political philosophy. That's how you become a federal judge or a Supreme Court justice. And it's for life, lifetime appointments. You cannot be removed from office based off decisions that you make. You can be impeached, though, for high crimes and misdemeanors. I'll give you an example, like accepting bribes as a federal judge. Accepting bribes. You can be impeached for that, dismissed, and other charges filed. Let me switch over some notes here. See where we are. Let's go a case to the court, a case to the Supreme Court. First of all, I want to look at three types of laws. There are three types of laws that I want you to be familiar with. And some of the other classes, we've already talked about this, so you can fast forward through this information. But I think R1, you need this information. First type of law is constitutional law. Laws based off of the Constitution, constitutional issues, constitutional law. Like in class the other day, we talked about the young lady who was a cheerleader, and she did not make the varsity cheerleading squad, so she went on a snap tirade against her high school while off school grounds, but the video got back to the school and they suspended her from the cheerleading team. She challenged it, her parents did, and the suit went all the way to the Supreme Court, which they heard arguments this past Wednesday, and they'll rule before the end of summer, or check that, the end of June. So constitutional law, or laws based off of constitutional issues. Speech issues, search and seizure, constitutional issues. Common law is judge-made law. Common law. When the judges, the justices rule on an issue, they are establishing, in a sense, a type of law, a precedent, if you will, which is a legal guide for future decisions. Write that word down, please, precedent. Not president, precedent, which is a legal guide for future court proceedings. You watch these legal shows all the time, and you'll see attorneys in front of the judge, and they'll refer to some case. They're citing precedent, letting the judge know, hey, there's other cases similar to this situation that we need to adhere to, especially if it's a ruling by the Supreme Court. Rulings by the Supreme Court establish precedents. You need to stare decisis. You need to follow the decision, let the decision stand. Statutory law. So this is the third type of law I want you to be familiar with. Constitutional, common, now statutory. Statutory law, or statutes, are laws created by legislative bodies. So laws created by the Indiana State Legislature or United States Congress. For going back to Timmy. Timmy was arrested for bank robbery. So Timmy was in violation of federal statute XYZ for bank robbery. That's what he's being prosecuted for. At the state level, I come rolling into the parking lot and I'm jamming NPR. You know, my bass is kicking, listening to some All Things Considered. I get pulled over by 5-0, the police. That's what we call them in the tough streets of Carmel, 5-0. I can be issued a citation for a decibel violation. Under Indiana statute 123, we have a decibel law. Am I playing my NPR way too loud? And if they want, law enforcement can issue me a citation on that. Or I'll give you a real life example. I was going through Columbus, Ohio a few years ago on my way to the East Coast, and I was driving a little fast, and I got pulled over. Wow, yeah, I know, I'm bad. And I was issued a citation for speeding because I was in violation of Ohio statute 678. I don't know what the number is, but I violated Ohio statute and they penalized me. I was in violation of the social contract, so I received a penalty. I had to pay a fine. I can't remember how much it was, but my wife, she'll remind me at times when I'm driving a little fast. So those are three types of law I want you to be familiar with for the exam. Constitutional law, common law, and statutory law. Remember those. So a case to the court. You'll see here in my notes. I'll post them online. There are steps to get a case to the Supreme Court. And I'm going to go through each step quickly. The first one is a petition. Let's go back to Timmy's case. So Timmy, he's convicted of bank robbery at the district court level. Timmy's attorney challenges the conviction on the grounds that the search of his automobile was unconstitutional, violating his constitutional right, Fourth Amendment right, to illegal search and seizure. So Timmy's attorney appeals it to the Court of Appeals, Seventh Circuit Court of Appeals out of Chicago. They look at the search and they say the search was legit, upholding Timmy's conviction. Well, now Timmy's attorney files a petition to the Supreme Court. So the first thing you're going to do is petition the Supreme Court to hear your case, to hear your argument. So that's number one, petition. So most petitions come from courts of appeals or state courts. Second is going to be what's called a cert hearing. Cert is short for certiorari. So to be made more certain, that's what it translates into. The Supreme Court receives hundreds and hundreds of petitions for each term. They're only going to hear, under the Roberts Court, probably around 50 cases a term, between 50 or 60. Remember, if they decide not to hear your case, the last ruling stands. So the justices, 9 justices, will go into a meeting and they will bring a list forward of cases they think they want to hear. The Chief Justice presiding over the meeting. Remember, the Chief Justice is not the boss of the other justices. The Chief Justice is more somebody who just keeps the meetings on track, more of a symbolic head, more of just something's escaping me. The word I want to say, it's just more of a, what's the word I'm looking for? It's right there, I can't remember. But the job of the chief is administrative, that's the word I was looking for. Whew. Administrative position, keeping the court running on task, doing what it needs to do, meetings and such. So administrative task of the Chief Justice. So the justices will meet and they will go over cases maybe they want to hear, and then they will vote on if they want to hear the case or not. They have on the court, they have what's called a rule of 4. And if you get 4 justices that want to hear a case, they're going to hear the case the next term. So let's say Timmy's attorney makes a petition, it comes up in the cert meeting, and 4 justices want to hear Timmy's case. They will issue what's called a writ of certiorari. So they're granting certiorari. In legal slang, they're granting cert. If they turn Timmy down, they would deny cert, and Timmy would probably be off to prison. But in this case, they're going to grant cert. The court really rejects 95% of petitions. The court will hear a case pretty much if it deals with significant federal or constitutional issues, or the lower courts from around the country have different rulings on the same topic. They will hear that case at the Supreme Court to make a decision between 2 conflicting lower courts on a legal decision or a constitutional principle. So they've granted cert hearing, writ of certiorari. A couple terms I have underneath that. One's called informa pauperis. It means, have you ever heard of the term pauper? The person's a pauper, meaning they're poor, they're indigent, they have no money, they're a poor person. Look at that term, informa pauperis. I have it underneath that. And standing. The court will want to know if you have standing to bring the case. Does the case you're bringing have a direct impact on you? Do you have standing to bring this case? And in this case, Timmy's attorney does. So the next step, number 3, the attorneys, the legal counsel will file their briefs on the case. Remember, they're not retrying the whole case. They're only looking at the legal argument on whether the search was legit. And that's what you're going to type up and submit to the justices. The argument you're making, the legal argument or the defense you're making, the brief. So you're going to send them, your brief, the case, your legal argument in brief so they can read it, what they're looking at, what's the argument here. So you submit them the briefs, legal briefs. Other individuals, depending on the case, if it's a big case, other vested interests can submit briefs as well. They're called amicus briefs. Amicus curiae, which means a friend of the court brief. So if it's a big argument, you can have other organizations submit their own briefs and their own views on how they would like the court to decide this case. They are allowed. So that's third, briefs. Now we've been scheduled for oral arguments. So that's the fourth part. So you will give a date and time you need to be there as the attorneys to present your arguments. Each side's going to get 30 minutes to get up there and plead their case to the justices. Or the justices, as soon as you start speaking, they're going to be, most of them will be questioning you right away. When Justice Scalia was on the court, he would just jump right in and start asking you all kinds of questions. Well, I shouldn't say that. Justice Thomas is noted for really not asking anything during oral arguments. When Justice Thomas asks a question during oral arguments, wow, note the date and time, because that's huge. He said he doesn't ask a lot of questions during oral arguments, Justice Thomas, because he's read it in the brief and he really doesn't need to ask a lot of questions. Actually, many times, the justices, when they do ask questions, they're not so much asking questions of the attorney present. They're having a conversation with another justice. They're using the attorney, though, as this post office box. So if I was a justice on the court, I'm going to ask a specific question, and knowing one of my fellow justices, the question was actually for them, not for the attorney, and we're going to have a conversation through the attorney. It's actually pretty good. So oral arguments, each side's going to get 30 minutes. It's rare for oral arguments to go over, but the courts have allowed it before to go longer than the allotted 30 minutes. So each side's going to present their case, and then later on the justices will go into conference. So about a week later they'll go into conference and they'll discuss the case, and then they'll vote. How do you want to decide this case? Then they'll issue an opinion on the case. So let's say in Timmy's case, let's say that they vote 5-4 to that the search was illegal. Ooh, the search was not legit. It violated Timmy's constitutional rights under the Fourth Amendment of illegal search and seizure. So, wow, and let's say the decision is 5-4. Woo, wow, split decision. Those are the decisions that get all the press. Those are the sexy decisions, the 5-4. The unanimous decisions, 9-0, boring, but it's the 5-4 ones, woo, big time. So let's say the decision's 5-4. So there are different types of decisions, 5-4. So the 5 individuals, the 5 justices, they would be in the majority opinion. So one of the justices will be assigned to write the majority opinion. Why did the 5 justices decide the way they decided? The 4, they are in the dissent. The 4 justices, they are the dissenters. They disagree with the majority, the 5. And they will, one of them, they'll write their own opinions usually of why they dissented. Concurrence. The justice can write a concurring opinion. So say you're in the 5, you're in the majority. You can write your own opinion, write a concurring opinion. I'm in the majority, I agree, but I'm going to write my own opinion on why. So these are in the notes as well. So they issue the opinion. Remember, when the Supreme Court issues an opinion, they're establishing a precedent, a legal guide for future court decisions. I have a picture of the justices, and that's it. 1-6 right there. So case to the court. Number 1, petition. Number 2, cert hearing. Number 3, briefs. Number 4, oral arguments. Number 5, conference. And number 6, issue the opinion. And then I have a picture of the justices. Know the justices. Know their names. There's a term I want you to be familiar with. It's also in your study guide. It's called judicial activism. Some believe that the court gets a little too political in their rulings. And there's a term, they legislate from the bench. They create legislative policy in their rulings. Yeah, sometimes they do. It happens. Sometimes they can be very radical and overstep their authority in their ruling. So be familiar with what's called judicial activism. You know what an activist is, right? An activist who's somebody who's really big into their views, their movements, and they want everybody to agree with it. So sometimes the justices, when they take on a ruling or they issue a ruling, they get a little activist in their ruling. It's called judicial activism. Are the courts too powerful? Do 9 unelected individuals, do they have too much power? You know, laws are supposed to be made by the legislative body, bill to law, by the people. Our courts, the federal courts, the Supreme Court, sometimes a little too overzealous in their rulings. So judicial activism versus judicial restraint. Should the court be issuing more focused, limited rulings and not delving into the political process? That's an issue that's heavily debated today. So look over your study guide closely on the judiciary. Check out this video and my notes, as well as other review videos for the exam on Monday. If you have any questions or concerns, text me, email me, get back to me ASAP. All right, Kavanaugh out.